Good morning and welcome to another edition of Law Talks here on 4CRB. Well, most people know they should make a will while they have capacity, but life doesn't always follow a neat timeline. Illness, injury, dementia or disability can sometimes mean a person no longer has the legal capacity to make or update their will. What many people don't realise is that in certain circumstances, the court can step in and authorise a will on someone else's behalf, known as a statutory will. Today, we're explaining what a statutory will is, when the court becomes involved, how decisions are made about a person's best interests, and why early planning can help families avoid needing this process altogether. We're joined by Attwood Marshall Lawyers, Estate Litigation Partner Lucy McPherson. Welcome, Lucy.
Thank you, Robyn. Thanks for having me.
Well, Lucy, let's start with the basics. What is a statutory will and why do most people not realise it exists?
A statutory will, I guess that's a legal term that we use to describe a will that is authorised by a court by virtue of the statute, hence the name, rather than an individual who is taking that voluntary intentional step themselves.
Okay.
It arises in circumstances where somebody may not have what we call testamentary capacity, which means capacity to make a will, but there is a need or a necessity for a will to be made in their particular family circumstances.
So when does the court step in to make a will for someone?
The court will only step in very limited circumstances. There has to be a necessity, a need for a will to be made in the circumstances of that particular person. Often we say that the need for a statutory will can be divided into two categories. We have the first category where somebody may have had testamentary capacity at some stage in their life, but they may have lost that capacity, usually due to something like Alzheimer's or dementia, and their family circumstances have changed. They may have become divorced, for instance, or undergone a property settlement, and there is then a need to change what was originally in place for them, having regard to, who else is going to be left over. So that's the first category. The second category is somebody who has never actually had the capacity to make a will. So, for instance, a disabled child, or a child that was injured in a catastrophic accident, and they've never been able to fully form what we as lawyers refer to as testamentary capacity, but often those individuals have quite a significant amount of wealth that needs to be considered because there can be personal injury claims and things like that involved. So they're the two categories that we often see this situation arising in, and then really needs to be that necessity for the making of a will in those circumstances. The court will only do this in very limited situations.
So, Lucy, we hear the term used often, loss of capacity, but what does loss of capacity actually mean in legal terms?
It's a really good question because the word capacity is thrown around so much when we come to legal discussions. What's really important to remember when we use the word capacity is that capacity is decision specific. So what I mean by that is the capacity to get married, or the capacity to make an enduring power of attorney, or the capacity to make a will. They're all different sets of legal tests. So the capacity to make a will is, for instance, different to the capacity required to execute an enduring power of attorney. And loss of capacity is where somebody is unable to satisfy that legal test that's in place. Now, in the context of making a will, there is a very old legal test that's in place and very established. The person, in order to satisfy capacity to make a will, must understand the assets over which they have disposing power. So they must be able to understand what is in their estate in broad terms. What assets do they hold, what bank accounts do they hold, what real property do they hold, et cetera, et cetera. And it doesn't have to be detailed, but they must understand in broad terms what they have disposing power over. They also must be able to understand the claims that could be brought on their estate. So those who they have a moral duty to provide for, they must be able to understand that as well. And they also must not have some sort of delusion that's affecting their mind and affecting those processes, those cognitive processes as well. Now, if you're unable to satisfy that test, and it's a legal test, not a medical test, then you're deemed to not have capacity to make a will.
And do lawyers make or do those tests when someone's trying to make a will?
Absolutely. So a good estate planning lawyer should be going through those legal tests when taking instructions for the making of a will, particularly where there are red flags in relation to potential lack of capacity. But ultimately, the decision about whether somebody has capacity or not is a decision for a judge.
And I was just going to say, who can apply for a statutory will?
So the legislation actually stipulates that this is quite broad. Somebody who has an interest in the matter can apply to the court for a statutory will. Now, that might seem quite broad, and it is, I guess, in practice, but the person who's bringing the application can't, say, for instance, have a significant conflict of interest.
Yeah, a vested interest.
Yeah, in the situation. The court's very unlikely to entertain an application in those circumstances.
And how does the court decide what is in someone's best interest?
Well, the court will look at the person's situation. So, who makes up their family unit, what are their assets, what sort of testamentary instrument or will is in place at the time of the application. And if there isn't a will, whether, what the rules of intestacy say with respect to the distribution of their estate. And for those that don't know what intestacy means, intestacy is just a fancy word for the legislation that dictates what happens to somebody's assets when they don't have a will, so how an estate is distributed in the absence of a will. And the court will consider all of those scenarios and whether the present situation is appropriate for that person's needs and their intentions. So the court will also consider the intentions of that person in making a decision about whether a statutory will is appropriate.
And are family wishes always followed?
I guess the short to that is no. Whilst a family's wishes will necessarily be considered by a judge has a very strict legal test to follow when deciding whether or not to make a statutory will, having regard to all of the matters that we've just discussed and whether it's appropriate in the circumstances to make a statutory will.
And is a statutory will meant to fix family conflict, or can it actually create more?
Well, that's one of the matters that a court or a judge should have regard to when deciding whether or not to make a statutory will is what sort of conflict may arise in the circumstances. And the court will always want to try and mitigate against future litigation. So mitigate against the potential for conflict to arise after the death of this particular individual.
And what can people do early to avoid needing a statutory will later?
Well, those who have capacity, so I spoke earlier about the different categories where a statutory will might be appropriate. So those who have capacity that lose it later in life, or those that don't have capacity at all. Now, for the category that have never been able to form capacity, there's not much that you can do to mitigate that risk.
No.
But for the category that, have testamentary capacity, then the easiest way to avoid needing a statutory will later is to make sure that you've got the appropriate estate plan in place when you do have the ability to make those decisions.
Yeah, we say it time and time again on this program. Lucy, thanks for joining us today and reminding us that planning early can make a significant difference.
Absolutely. Thanks for having me, Robyn.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.